Charlebois, may I hear from you, please?
Thank you, Your Honor. And, Your Honor, I will follow Mr. Hull's lead in speaking directly to the audience.
That's fine. It's okay with you.
I will be addressing Mr. Shapiro's claim for support from the deceased's estate under the Succession Law Reform Act. And in the notice of application, he specifically bases this claim on a moral obligation. It's the estate's position that Mr. Shapiro does not have a valid enforceable claim for support. He does not meet the threshold test under Section 57 of this SLRA in that the deceased was not providing him with support immediately prior to his death, nor was the deceased under a legal obligation to provide him with support immediately prior to his death. Absent meeting that threshold test, we do not get to the point where moral considerations come into play. The applicant cannot establish that he has a right to share in his father's estate based on the provisions of the Act, and the Ontario case law supports that view. There is no Ontario case that founds a right for an independent adult child to share in a parent's estate under the Succession Law Reform Act, and the case law surrounding this issue does not provide the basis for Mr. Shapiro succeeding here today. In the circumstances of this case, the deceased's testamentary freedom, an important public policy goal, must prevail. You've heard the facts. We've heard Mr. Shapiro be cross-examined. He's sworn an affidavit. He's 29 years old. By his own admission, he is financially independent and self-sufficient. He enjoyed significant financial benefits during his lifetime at his father's hand. He went to private schools. He went to summer camps. His entire tuition at Columbia was paid for. His father gave him $250,000 to start his own business. But he is now at the point where he is successful, self-sufficient, and is in no need of any financial support from this estate. And by his own admission, he was not being supported prior to death. Yet he now asserts that he is entitled to a share of his father's estate under the support provisions of the SLRA. And that is notwithstanding his father's express intention and wishes to exclude him from his estate. And the starting point for the analysis is Part 5 of the Act, and that's the legislation under which Mr. Shapiro has to establish his right. In Mr. Hull's factum, I believe that's at tab 4B in the estate's factum, the provision that we need to look at is at Schedule B of the factum. And the starting point is Section 58 of the Act, which says where a deceased, whether testate or intestate, has not made adequate provision for the proper support of his dependents or any of them, the court on application may order that such provision as it considers adequate be made out of the estate. We then have to go back to the definition of dependent, and this has already been spoken about and I've already referred to it. It does include a child of the deceased, but it has to be a child to whom the deceased was providing support or was under a legal obligation to provide support immediately before his or her death. The goal of the legislation is clearly to provide a remedy to financial dependence of the deceased where inadequate provision has been made by the deceased in his will. It is not to found a basis for an independent child to claim what he or she thinks is his moral share of a deceased's estate. This section cannot permit a moral claim to trump the deceased's intention. If all children had a moral claim to a share of their parents' estate, then the section wouldn't be defined as it is. The qualifying language, at the end of the definition of dependent would be unnecessary if we all, as children, had moral claims to a share in our parents' estate. There would be no need to establish that the deceased is either providing support or under a legal obligation to provide support. We have to give meaning to the words in the statute. We have to give it the intention and the purpose it was designed to deal with. If the framework for support claims is going to be altered as dramatically as now proposed by the applicant, that is not the role of the court. That is the role of the legislature. This testator has made a decision as to how he wishes to dispose of his estate, and absent legal dependency, that cannot be interfered with and should not be interfered with. While we may not like the result, while some of us may disagree with the end result of this case, it was the testator's prerogative to legally exclude his child from a share of his estate. And that child does not have any absolute right to share, absent meeting the test under the legislation. So then we have to look at the case law. It's been submitted that somehow the Ontario case law gives Mr. Shapiro the right he is now claiming he has. He takes the position that despite the clear wording, of the statute, the case law establishes a right to support based on moral grounds. I respectfully submit that there's no basis for that assertion. There's no case in Ontario in which a court has indicated there is such a right. The starting point for Mr. Shapiro's argument appears to be the Tattern case, the Supreme Court's decision based on the BC legislation. But that was based on a very different statute, a statute that does not require dependency in order for the court to intervene in a testator's scheme of distribution. Rather, in BC, the court must determine whether adequate provision has been made for a spouse and children. That provided the court in BC, and therefore the Supreme Court, with much greater flexibility and discretion as to what was adequate, just, and equitable. But the case was decided in that context. Our legislation speaks of dependency. Dependency is a prerequisite to any entitlement under the section, and that has not been altered by the case law and cannot have been altered by Tattern because it was based on a different statute. That brings us to the Cummings decision, which is the decision which is said to have moved in the direction of Tattern. But the Cummings decision was a context between dependents. We had 4 individuals whose interests were considered. They were all dependents of the deceased. There was a wife, an ex-wife, and 2 dependent children, a son who suffered from a degenerative disease and a daughter who still had educational needs. There were no claims in Cummings being advanced by independent children. And in that case, none of the parties was advancing a claim based on moral grounds. The issue of whether a moral claim could found a support order under the Act was in no way considered in Cummings. Rather, the court was considering, once dependency was established, whether moral considerations could come into play. And they can, but that is at the second stage of the analysis. Once you meet the prerequisite in that you are a dependent of the deceased, the court then can balance many considerations, including moral considerations, in determining a proper allocation of the estate. And that becomes particularly important, whereas in many of these cases, the estate is of quite limited means, and there are competing interests and demands for the funds left in the estate. And if we look at the court's decision in Cummings, it's clear that that is what is being done. And that case is at tab 5A of the brief. And at paragraph 34, the court says, the issue whether, and if so to what extent, moral or ethical considerations may be taken into account on a dependent's relief application in Ontario has not been dealt with at the appellate level. It goes on to say, in this case, the question is whether, in considering an application for relief on behalf of one or more dependent,
The court may take into account not only the needs and means of those dependents, but also the moral obligations of the deceased person to another dependent who is not asserting a need. The answer to this question must be yes. So we are talking about a contest between dependents. We're not talking about assessing whether independent children have needs and whether there is any moral obligation to include them in a share of the deceased's estate. Paragraph 42, the court explicitly recognizes in saying, secondly, the beneficiaries, and this is about two-thirds of the way, three-quarters of the way down, paragraph 42. Secondly, the beneficiaries of the British Columbia statute are not limited to dependent spouses and children, whereas that is the case in Ontario. So the court explicitly recognizes that our legislation is different. Our legislation is limited to dependents, and that is not the case in BC. And again, at paragraph 50, when the court is examining the circumstances of an application for dependents relief, the court must consider, and at B, what moral obligations arise between the deceased and his or her dependents. So again, we are talking about moral considerations, no question, but it's in the context of moral considerations when we are looking at competing claims between defendants or among dependents, in an estate. So none of what I've talked to you about so far, neither of these two cases provide any basis for Mr. Shapiro's claim against this estate. What Cummings is talking about is the flexibility that can be afforded to a court in terms of determining what is a proper allocation of a deceased's estate. And it really looks at the shift from a needs-based analysis, which was historically what the court was looking at, to taking a broader, more flexible approach that allows the court to consider moral obligations. Nothing in Cummings permits Mr. Shapiro to sidestep the critical requirement under the legislation that he demonstrate dependency. And really to suggest that Cummings does otherwise is to conflate the two-step test under the SLRA, which is one, are you a dependent? And two, at the second stage, if you are, what is the proper level of support to be awarded? It is only at the second stage that the moral considerations come into play. In his affidavit, Mr. Shapiro relies on Justice Henderson's decision in Pirelli and Foley. I respectfully suggest that is misplaced. Again, Pirelli was not a case in which the independent adult children were advancing claims under the SLRA. Rather, the deceased had left his estate to his independent adult children, and the estate was then faced with a claim by the common law spouse for both support and unjust enrichment. So it wasn't a case where the court was evaluating whether the children on moral grounds should share. It was a case of balancing the support claim by the spouse with the bequests in the will to the adult independent children. So that case, in my submission, doesn't help at all. The court was trying to figure out how much it should compromise the adult children's benefits under the will, which the deceased intended for them, with the spouse's legitimate claim both at common law and under the statute. So the court, therefore, naturally and properly considered moral obligations and moral considerations in balancing these competing interests and determining what distribution was ultimately appropriate. This case did not in any way create a freestanding right for an independent child to advance a moral claim under the SLRA. So, in summary, I think I'm running out of time. There is, in my respectful submission, no basis for Mr. Shapiro's claim. He cannot establish that he meets the test under the SLRA. He cannot establish that the case law has somehow fundamentally altered the test in the SLRA such that he is entitled to advance a moral claim to a share of his father's estate. There is absolutely no basis in this case to interfere with the deceased's testamentary intentions. The courts have repeatedly recognized the importance of those public policy considerations. And yes, in certain cases, we do have to interfere and infringe upon a testator's right to dispose of his or her property as he sees fit, where there is legal dependency. But this is not one of those cases. And in this case, it is my respectful submission that there's simply no basis to infringe upon the deceased's autonomy to dispose of the estate as he chose to do. And those are my submissions, Your Honor.
Thank you, Ms. Charlebois.
Subject to any questions you may have.
Thank you. I do have a few questions. My first question is the question of what is meant by support in the SLRA. The definition, support is not defined in the SLRA. Why are you restricting it to financial support and money? There's case law that suggests that support is a much broader concept and broader than just financial support.
The case law you refer to, I've read and I've seen it. I don't think it extends as broadly as will need to be submitted by my friend in terms of support to Mr. Shapiro. There's no question that when we are looking at whether he's entitled to a provision of his father's estate, we are talking financially. So sure, there's other types of support, but when we're talking about provision out of an estate, we are talking about financial. And this testator has supported his son throughout his lifetime. He's been very generous. And the question you ask, I suppose, is whether this support can take on a broader meaning in the context of the statute. I don't think it goes so far as to say it entitles you to a share in an estate. I don't think the support concept can be stretched that far. I do not think that's what the statute was intended to provide. And as I said, if the legislation is going to go that far, I think that is a matter for the legislature because clearly support has connotations. And to the extent that we want to stretch it further than it's intended, I don't think that's our place. I think that is something that needs to be done more formally at the legislative level because the intention of the Act, the clear intention when you look at how it was drafted, was to provide for financial support for dependents who required that support from the deceased immediately prior to his or her death.
That's an excellent answer. Thank you. Those are my questions. Thanks.
Thank you, Your Honor.
Thank you.